In papers before the court, Trillian says although it had no contract with Eskom, it did not mean there was no valid contractual basis for payments. It says the amounts received from Eskom were for the work done and services rendered as a subcontractor to McKinsey. Trillian submits that it had received amounts in good faith without knowledge of any irregularities in the procurement process, and that its subcontracts with McKinsey were not automatically unlawful, even if the McKinsey contracts with Eskom were. The appellants contend that it was not just and equitable to repay because the work had been done and that Eskom had benefited greatly.
The only legality that the court, or rather ruling that the court can pass in this instance, is for Trillian to repay back the money, which the part of it they've already agreed to repay, but the other part they are saying that they're not going to repay it back. But in all essence, the basis of the application relates to the illegal agreements which were then entered into between Eskom and Trillian. So if they want to appeal that, I don't foresee the Supreme Court overturning the ruling of the Supreme Court of overturning the ruling of the Pretoria High Court.
The High Court ruled in favor of the cash-strapped power utility and ordered that Trillian pay back almost 600 million rand in public funds that were unlawfully received from Eskom, and that the payments to Trillian had no lawful basis and have all the hallmarks of fraud and corruption. In papers before the appellate court, Eskom argues that Trillian is now in breach of the High Court order. Eskom says Trillian's ongoing breach of the order is sufficient reason to dismiss this application for leave to appeal with punitive costs. Aphumelele Mdlalane, SABC News, Bloemfontein.